Hello, my name is Surbhi Kuelkar. I am a graduate of the batch of 2013 from the National Law School of India, University, Bangalore. Thereafter, I worked as a clerk to the Chief Justice of India, and I shall be presenting today the module on right to dignity, privacy, and autonomy as part of comparative constitutional law. By way of structure, we shall first look at dignity, privacy, and autonomy as concepts. And while looking at each of those, we shall also look at how India has dealt with these three concepts in the constitution as well as through case law. Thereafter, we shall move on to three issues which shall discuss each of these concepts, which is euthanasia, followed by gender and sexuality issues, and followed by abortion. To start with, looking at the concept of dignity, the incorporation of the concept of human dignity in the Universal Declaration of Human Rights was the culmination of significant historical evolution of the concept. Notably, it had prior proponents such as Immanuel Kant. Kant's understanding of human dignity required that individuals should be treated as the ends and not simply the means to an end. He propounded this in the Metaphysics of Morals and section 38 of the Doctrine of Virtue. This was further then propounded in the work of Rawls, Dworkin, and Nozick more recently. Significantly due to its centrality both in the Universal Declaration, the United Nations Charter, as well as other documents, the concept of human dignity now plays a central role in the human rights discourse internationally. The ICCPR, the ICESCR both state that the human rights derive from the inherent dignity of the human person. Dignity is hence becoming commonplace in legal texts, providing for human rights protections in many jurisdictions, most notably in bills of rights and the constitution of various nations. Ultimately, the concept of dignity came to be used as a rallying cry for a variety of other social and political movements, advocating specific types of social reform during the 19th and 20th centuries. These movements included movements to abolish slavery, against the Holocaust, civil rights movements in the United States, and in the articulation of feminist demands concerning the role of women, for example, for reproductive rights. Dignity is playing a major role in discussions on the ethics of biomedical research as well. In the area of bioethics, it has been made a central issue in discussion of reproductive rights, as was priorly mentioned, in campaigns on the issue of appropriate treatment at the end of life, and in the issue of genetic manipulation, not least because of the influence of the Catholic Church. More generally, dignity has increasingly passed into vernacular use in a variety of different contexts and circumstances. Dignity has also been drawn on in the international political context, most notably in the critiques of communism and as a moral basis of attacking global poverty, all of which we will not discuss in detail during this module. Furthermore, dignity over time has been recognized as a part of Article 21 of the Indian Constitution. In the noted case of Maneka Gandhi, a 7-judge bench gave the widest amplitude to the term liberty under Article 21. Interfering with this right would require satisfaction of a 3-step test. First, there should be a prescribed procedure. Secondly, the procedure should withstand a test of one or more of the fundamental rights under Article 19. And 3, it must also be liable to be tested with reference to Article 14. India had recognized the right to live with dignity and a life of good quality consistent with human personality thereafter. This has also further been looked at in a number of cases such as M.H. Hoskote versus Maharashtra, Hossainara Khatun, which dealt with rights of under trials, Francis Corley Nalin versus Union Territory of Delhi, Olga Tellis versus Bombay Corporation, Vikram Dev Singh Tomar versus State of Bihar, and decisions such as P. Ratnam versus Union of India and noise pollution and environmental law cases, all of which are not discussed in detail in this visual module. Coming to the right to privacy, every person has the right to enjoy his life without any interference. Hence, the right to privacy has been formulated. In India, there is no explicit mention of the right to privacy under the Constitution. However, the courts have read the right to privacy into Article 21, which guarantees the right to life and personal liberty. Internationally, the right to privacy finds mention in Article 8 of the European Convention on Human Rights, which was adopted in 1950. This protects the right to private life. Everyone has the right to respect for his private and family life, his home, and his correspondence. Through the huge case law of the European Court of Human Rights in Strasbourg, privacy has been defined and its protection has been established as a positive right of everyone. Article 17 of the International Covenant on Civil and Political Rights of the UN of 1966 also protects privacy, which reads that no one shall be subject to arbitrary or unlawful interference with his privacy, family, home or correspondence, nor to unlawful attacks on his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. In the United States, the right to privacy commences as a tort remedy and was then expounded on later by persons such as Dean Prosser. Originally, it was discovered, so to speak, as a remedy by Warren and Brandeis in their seminal piece. Dean Prosser, for instance, propounded that privacy was a combination of 4 torts concerning a violation of 4 different interests. This meant it was the combination of intrusion on seclusion or solitude into private affairs, of public disclosure of embarrassing facts and publicity in the false light, which involved the interest of appropriation for defendant's advantage of a plaintiff's name or likeness, protecting the interest of freedom from mental stress, reputation and proprietary interest in name and likeness. On the larger question of why privacy is protected, among other things, the first is that activities in the home harm others only to the extent that they cause offense resulting from the mere thought that individuals might be engaging in such activities and that such harm is not constitutionally protected by the state. The second is that individuals need a place of sanctuary where they can be free from societal control. The importance of such a sanctuary is that individuals can then drop this mask, desist for a while from projecting on the world the image that they want to be accepted as themselves, and an image that they may reflect the values of their peers rather than the reality of their own nature. Hence, essentially, to give an individual a private sphere, privacy is protected. Moving on to autonomy as a concept, autonomy was an extension of the concept of dignity. To treat people with dignity meant to grant them the autonomy to make reasoned decisions for themselves and often was considered an extension of Kant's philosophy. Autonomy is also akin to what is termed as bodily integrity or the right to make decisions regarding one's own body by oneself. For instance, needing informed consent for the purposes of medical treatment of an adult. Autonomy has also been considered an extension of privacy in terms of having the right to make one's choices as regards, for instance, sexual orientation, reproductive choice, etc. Cases are discussed hereafter in the module in an issue-specific manner. Autonomy is also inextricably linked to making informed and free preferences that defines one's present and future courses of life without interference from any outside agency, which also is where the nexus between autonomy and dignity becomes apparent as independent from privacy. Privacy in itself has twin strands of self-autonomy, dealing with an individual and what acts of his should be private, and spatial autonomy in terms of places around an individual which should be away from state interference, such as his home. Looking at privacy and autonomy in a nutshell as part of Article 21 of the Indian Constitution, our Constitution does not contain a specific provision as to privacy, but the right to privacy has, as we shall presently show, been spelt out by the Supreme Court from the provision of Article 19(1)(a) dealing with freedom of expression, Article 19(1)(d) dealing with the right to freedom of movement, and Article 21. The Indian law has followed the US law laid down in many different cases, for instance in Olmstead versus the US and Griswold versus Connecticut. In these matters, notably the Delhi High Court in cases such as Naz and even the Supreme Court in the Nalsa and other decisions, along with Kharak Singh, etc. In 1964, in Kharak Singh's case, the case of the United States in Mann versus Illinois was followed, and it was held that though our Constitution did not refer to the right of privacy expressly, still it could be traced out of the right of life in Article 21. Law of privacy developed by Matthew J. in the case of Gobind Singh thereafter and picked up from where Kharak Singh had left off. US cases were cited in that decision to hold that privacy could be contravened only if important countervailing interest was shown to be superior or where a compelling state interest was shown. More recently, a two-judge bench in R. Rajagopal versus the state of Tamil Nadu held that the right to privacy is implicit in the right to life and liberty guaranteed to the citizens of India by Article 21. Moving on to an issue-by-issue analysis of how these rights have developed as part of constitutional law, the first issue we take up is euthanasia. Euthanasia also includes different discussions on the right to life, the right to live with dignity, as well as the right to die. Just by way of introduction, there exists active euthanasia, which involves actively administering life-terminating drugs to a patient, passive euthanasia as contrary to active, voluntary, which involves voluntary acts on part of a patient through consent, and involuntary euthanasia, in contrast to voluntary euthanasia, which is all different from assisted suicide, which assisted suicide by a physician, and voluntary passive euthanasia. Voluntary passive euthanasia and assisted suicide are legal in certain jurisdictions, and active euthanasia is illegal in most jurisdictions. Physician assisted suicide is different from passive euthanasia, as it is merely stopping life supporting treatment and is legal in some parts of the world, for instance in some states of the United States. Killing terminally ill to end suffering is again different from killing a person whose life is not worth living, as it is socially useless, as a distinction that is made in what can be termed as legal termination of life and illegal. The individualistic legal system and man was endowed with innate personal dignity, being an end in himself and not merely serving an extraneous ends of the state or of fellow human beings. No exculpation or reduction in penalty could hence be there should there be mercy killing for the benefit of anyone other than the suffering patient. Respect for dignity also implied recognition of human will as of value. Hence, decisive significance of the patient's consent or request follows from this evaluation of euthanasia in terms of what rights and what processes are involved in mercy killing. In India, the landmark case on point is the case of Aruna Shanbag, which was the case of a nurse who was strangulated and raped within a hospital environment. Prior to this, the decision of Jian Kaur held field, wherein the court had held that both active euthanasia and assisted suicide was illegal. The right to live with dignity therein had been taken to include the right to die with dignity, including a dignified procedure during death, should death be imminent. Reduction of suffering in such cases by termination with help was which was a physical act was considered. However, it was held that the contention that the right to life included the right to die was incorrect. Arguments made before the court in Aruna Shanbag included how Article 21 had expanded to include life with dignity, which a suffering person could have. The court noted this case prior law in the US definition of death and brain damage. The question of who could terminate the pregnancy who could terminate life should the patient not be able to give consent was left open by courts previously in the case of Jian Kaur. The assumption being that after a patient was in a particular state, consent to terminate life could not be present. Based on standards of when a person could be considered dead, it was held that Aruna Shanbag in this case was not a dead person who could not give consent. Guidelines were hence laid down under Article 226 jurisdiction, wherein it was noted that based on the principle of parens patriae, where a person could not take a decision himself, the state would do so on his behalf. In considering such decision, opinions of parents, relatives and the next friend, in the case of Aruna Shanbag, the hospital staff of KEM hospital in Mumbai, should be given due weight. Here, principle of best interest of the patient was required to be taken into account. The references made to dignity, privacy were in the passing in this case. Autonomy and the grant of consent formed a large part of the discussion. In the UK, the case of Eredal was where the right to die was discussed and was held that this could not be made lawful only by legislation. This was a decision of the House of Lords. Now, the Mental Capacity Act of 2005 has been introduced to help the substitution decision making process. In the United States, there has been a large amount of discussion again on this issue. The basic right to die statute in the United States in some states legally recognizes the right of a competent adult to refuse life-prolonging procedures if that adult is terminally ill. This was seen to be exercised in Oregon recently in the case of Brittany Maynard. Being a state and not federal statutes, they are not identical across states, but each, however, contains basic similarities which provide necessary legal guidelines. This is usually considered in a criminal context in the United States as part of criminal law. That is, euthanasia is not considered in part of the context of constitutional rights, but more as part of a criminal statute should it be done without permission. Other cases that have dealt with this in the United States include Washington versus Gluckenberg and Wacko versus Gill of the United States Supreme Court. The case of Cruzen versus Director MDH is also discussed briefly here. In that case, it was held that bodily integrity or the right to decide what shall be done to one's body rests with an individual. The surgeon, for instance, a surgeon performing an operation without consent commits a punishable assault. This was also held in the case of Schoendorf versus Society of New York Hospital. In the case of Inre Quinlan, which was also cited in Cruzan, the New Jersey court held that the patient in a permanent vegetative state had the right to privacy grounded in the US Constitution, which could be exercised so as to allow her guardian and family to decide if it should be exercised at all. Last, in the case of Inre Conroy, also cited in Cruzan, it was held that should consent not be present, termination of life supporting treatment could take the place for the reason of them being inhumane. In Australia, it has been held that in various cases that for instance, in the case of a quadriplegic Christian Rossiter, that he was allowed to stop life-saving medication, which was tube feeding, to abide by his wishes, and that the carers would have to abide by his wishes, and they would not be responsible for following his instructions should he eventually die. Previously, Australia had a legislation in its Northern Territory, which was the Rights of the Terminally Ill Act in 1997, which allowed assisted suicide, but which was then overturned by the federal parliament. Many other jurisdictions also use the argument of bodily autonomy for the purposes of justifying the right to die, which have not been discussed in detail in this module. Moving on to the issue of gender and sexuality, where the issues of dignity, privacy and autonomy arise very often. In India, most recently transgender rights were recognized in the lauded Nalsa decision by the Supreme Court, wherein Justice Radhakrishnan stressed on privacy, equality and dignity as part of Article 19(1)(a) and Article 21. This decision touched on similar issues which had been looked at in the decision of Naz Foundation versus NCT of Delhi, which was later overruled by the Supreme Court decision in appeal called Suresh Kumar Kaushal versus Naz Foundation, wherein section 377 of the IPC was said not to violate dignity and privacy of homosexuals in regulating conduct between consulting adults in privacy even. This also in the process overruled what some believed to be was a path-breaking decision by the Delhi High Court, wherein those rights were in fact recognized explicitly explicitly basing that decision in foreign jurisprudence. In Nalsa and Naz of the Delhi High Court, courts had extensively relied on foreign precedent on privacy, dignity and integrity, including the rights to personhood. In Naz, for instance, the court states that the right to privacy was incontestably an aspect of personal liberty as upheld by a string of decisions and could only be restricted by showing compelling state interest, which was not shown in the case of consenting adults and sexual acts between them, which had previously been included in section 377 of the IPC. By way of example, in the United States, criminalizing homosexuality was held unconstitutional on the following among other bases in cases such as Lawrence versus Texas and Boers versus Hardwick. To quote Lawrence versus Texas, in these matters involving the most intimate and personal choices a person may make in a lifetime, choices central to a person's dignity and autonomy are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under the compulsion of the state. Other cases put sexual relations between adults beyond the reach of interference of the state. Instances of this, as mentioned previously, are Griswold versus Connecticut, wherein the court invalidated a state law prohibiting the use of drugs or devices of contraception and counseling or aiding and abetting the use of contraceptives. After Griswold, it was established that the right to make certain decisions regarding sexual conduct extends beyond marital relationships. In Einstein versus Baird, it was held that one could not ban the sale of contraceptives to unmarried persons by law. This is in certain other jurisdictions as well. These issues have been looked into and have held that criminalization based on these grounds is incorrect. In Dudgeon versus UK and Norris versus Ireland, the violation of privacy was held to be contrary to Article 8 of the ECHR. Toonen versus Australia similarly held this to be a violation of Article 17 of the ICCPR. The National Coalition for Gay and Lesbian Equality versus the Minister of Justice was a South African case which held that the way in which one gives expression to one's sexuality is at the core of this area of private intimacy. If in expressing one's sexuality one acts consensually and without harming the other, invasion of that precinct would be a breach of privacy. This was Justice Ackerman in that case. Sodomy laws in Hong Kong, for instance, were also struck down by the High Court there in cases such as Long T.C. William Roy versus Secretary of Justice. Coming to the last issue of abortion, in India, the Medical Termination of Pregnancy Act allows for abortion within 20 weeks of pregnancy. By way of example, a case that can be discussed here to see how this fits into the constitutional dialogue is the case of Suchitra Srivastava, wherein the Supreme Court held that women have the right to dignity, privacy and bodily integrity, the right to contraception and the right to refuse to participate in sexual activity. Reproductive autonomy was an integral part of a woman's right to life under Article 21. It rejected the exercise of parents' patriae powers to alter the appellant's decisions in that case and asked the state to ensure healthy delivery and postnatal care for both the mother and the child. This was these issues regarding reproductive freedoms as well as the right to privacy and disclosure in a sexual context was also dealt with in the case of Mr. X versus Hospital Y, wherein a disclosure of a doctor to a patient's fiancé about him being HIV positive was not considered a problem. In terms of other jurisdictions, in the context of abortion, the US law is important to look at, from which Indian law has borrowed extensively. Commonly cited is the case of Jane Roe versus Wade of the United States Supreme Court in 1973, which was the case in which an unmarried pregnant woman who wished to terminate her pregnancy by abortion instituted action in the United States District Court for the Northern District of Texas, seeking a declaratory judgment that the Texas criminal abortion statutes, which prohibited abortions except with respect to those procured or attempted by medical advice for the purpose of saving the life of the mother, were unconstitutional. The court said that although the Constitution of the United States did not explicitly mention any right of privacy, the United States Supreme Court recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy did exist under the Constitution, and that the roots of that right may be found in the First Amendment, in the 4th and 5th Amendments, in the penumbras of the Bill of Rights in the 9th Amendment, and in the concept of liberty guaranteed by the first section of the 14th Amendment. Another case which is significant in this context is the case of Planned Parenthood of Southeastern Pennsylvania versus Casey, which was decided in 1992. The court herein again confirmed the constitutional protection to the personal decisions relating to marriage, procreation, contraception, family relationships, child rearing and education. In explaining the respect the Constitution demands for the autonomy of the person in making these choices, the court stated that these matters involving the most intimate and personal choices a person may make in his lifetime, choices that are central to personal dignity and autonomy and are central to liberty protected by the 14th Amendment, are very important. At the heart of the liberty is the right to define one's own concept of existence, of meaning of the universe and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. These issues that have been dealt with in these presentations also arise in other areas of law, such as debates around the death penalty, for instance. Those have not been discussed in detail in this module, but cases that deal with them both in India and other jurisdictions are relevant to the issue. Just by way of recap, what has been dealt with in this module includes what the concepts of dignity, privacy and autonomy mean and how they originated, how they have been accommodated within the Article 21 jurisprudence in the Indian discourse, and also how they have been accommodated in the discourse of other jurisdictions. Thereafter, we dealt with euthanasia, with the concept of gender and sexuality and rights of privacy, dignity and autonomy in that context, and last with the issue of abortion and how these concepts are relevant therein as well. Thank you.